Hello, I would now like to talk to you about perhaps the most important disclaimer of onerous property case, at least in the context of leases as the species of property that can potentially be disclaimed pursuant to section 178 of the Insolvency Act 1986. Why is it the most important case? Well, arguably it's important because first, it's a House of Lords decision, and of course it's the decision in Hindcastle and Barbara Attenborough Associates Limited, 1997 square brackets appeal cases at page 70. So the first reason it's important is because it's a House of Lords decision, and in particular it's the opinion of Lord Nichols of Birkenhead which is noteworthy for us to examine. And that takes us to why it's important, and the second reason for importance is because it involves Lord Nichols of Birkenhead, who is of course a graduate of this university, that's to say the University of Liverpool. If you're interested in his judicial career, you can examine his recollections here, his memoirs, very interesting book that does feature a number of his cases. We will now mull on one of his cases, namely of course Hindcastle and his opinion in that case. So it's a disclaimer case, and it relates to a lease, in particular a lease for 20 years. There were various parties involved in the lease. Of course, the original landlord and the first leasee, a surety, guarantor, and then finally our insolvent company. And that is a company called Prest Limited. And the question before the law lords, as they then were, was essentially, can you exercise a disclaimer pursuant to 178 of the Insolvency Act 1986 as a liquidator with the effect that the entirety of the lease and its obligations are extinguished for the insolvent company only, in this case Prest? So do the obligations that Prest owe pursuant to the lease become extinguished pursuant to the disclaimer, leaving the lease in some way in existence, so that, for example, the surety or the guarantor would still have to honour the obligations that the lease required in terms of rental payments. And of course the alternative to that proposition or position is that the lease is extinguished in its entirety and therefore nobody is liable post the disclaimer. The House of Lords, in reversing a 90-year long held run of authorities, hold that the effect of a disclaimer pursuant to section 178 of the Insolvency Act is to disclaim the obligations pursuant to the lease, that onerous property, for the insolvent company only. And that means, of course, then that the surety and guarantor are liable for the obligations under the lease post the disclaimer. And this is perhaps not a surprise, because of course you would probably expect that it to be the case that if a company goes insolvent, that a surety or a guarantor would have to step up to the plate and make good any obligations that are owed. And Lord Nichols of Birkenhead in this regard does rely on a very early authority, an early 19th century authority, which is instructive in this regard. And that's a case called Inglis and McDougall, 1817, 1 MOO Rep 196 is your citation, and it's Gibbs, who is the Chief Justice who heard the case, and He said this: "The very object of taking sureties is to provide against the insolvency of the principal, and the object of the Insolvent Acts and statutes applying to bankrupts is to discharge debtors and bankrupts from obligations, but not to disturb the claims of creditors on other persons, as sureties from the failure of such debtors or bankrupts." Lord Nichols of Birkenhead applies that early 19th century case, and amongst other authorities, to the position of Prest and the surety that's involved in this multiple relationship from the leasee, assignees, sureties and guarantors, and then eventually the ultimate assignee, Prest, down here at the bottom. Once Prest goes insolvent, can those other actors be held liable? And of course the answer is yes, pursuant to the surety obligations that they owe. So the case is, in summary, important because it reverses that long line of authority, it makes sureties liable in the event of disclaimer, and it also shows that, as Lord Nichols of Birkenhead says, excuse me, over the course of time we have fluctuations in the property market, which mean that entities like Prest end up paying far more in rent than the original obligations that they took on because of termly rent increases, and that on the advent of sticky position globally for property prices, when rents come down in a recession, a company such as Prest can be left with burdensome obligations in terms of exposure, so that the rent they're paying is well in excess of the current market value of like properties. It's therefore not a surprise that we'd find the office holder, the liquidator, wanting to disclaim that onerous property. This is particularly important in the modern context and the environment which we now find ourselves in April 2018, where we see lots of CVAs, company voluntary arrangements, being proposed by office holders, the supervisors of those CVAs, for entities like Toys R Us, for example, where compositions are being arranged with landlords because of this tension, this idea that rent obligations are stymieing the way in which these entities can progress. They're being overburdened with their rent obligations. So enjoy looking through that House of Lords decision, the very eloquent discussion that Lord Nichols of Birkenhead presents in his opinion as he read it to the House of Lords back in 1997. Do have a look, as I say, at his memoirs and recollections to see what you think about those. And most of all, enjoy the case. And the case, of course, is that disclaimer case, Hindcastle, which looks at the provision 178 in the context of leases. Until our next video, I bid you goodbye.